Okay, everybody, I think we can get started now. Hello again, my name is Neil Andrews. As I mentioned, I work for IASP as the editor of the Pain Research Forum and Relief. In case you're not familiar with Pain Research Forum, PRF, it is our online website and virtual community for pain researchers throughout the world, where we cover pain research for researchers. And Relief is our companion website for the public, where we translate the research that we cover on Pain Research Forum into more accessible language suitable for patients and the public. So again, I'm really happy to be here today to be moderating this special ISP webinar to be presented by Brendan Delaney on the topic of travel visas for international attendees who will be traveling to Boston in September for the World Congress on Pain. We are really looking forward to seeing you all of you there. It's going to be a great event. Before saying a bit more about the webinar, I just wanted to bring your attention to some information about the Congress, and you'll see some information on the screen now. So early bird rates are still in effect, so we encourage you to register early to get a nice discount. The scientific program is now available. It's interactive. I wanted to mention that you can search by topic, keyword, speaker, and session type and begin building your personal Congress itinerary. If you've registered for the Congress, you can log into the itinerary planner and save your schedule. Something very exciting and new for this year is that we are offering hands-on practical workshops as part of the scientific program. And we're actually offering 3 hands-on practical workshops as part of the program. These workshops are actually eligible for continuing education credits, and they are available at no cost. Although registration is required due to limited space, the 3 different workshops will include a neuromodulation cadaver workshop. There'll also be a workshop on QST demonstration and hands-on, and there will actually also be an ultrasound workshop about guided interventions, both diagnostic and therapeutic interventions. There are also a great variety of special sessions being offered in addition to the scientific program. This includes a session on pain in elite athletes. So this will actually be a 2-part session featuring former professional athletes and the chief medical officers from the organizations, including the NFL, which is the National Football League, the NCAA, and the chair of the International Paralympic Committee, Medical Committee. So that's going to be a great session. There's also a special session called Breaking Through the Clutter, and this will be a workshop with communication and media professionals to help you engage effectively with non-scientific audiences. We'll also have a session on advocating for pain relief worldwide, best practices from around the globe, and there will also be 2 special Global Year sessions. This year it's the Global Year dedicated to excellence in pain education, and so there'll be a special session on that topic. Also wanted to mention that space will be limited for all of these events and they require additional registration. Some of them are available at no cost, some will require an additional fee, and you can register for these when you register for the Congress. And again, please don't forget, time is running out to register at discounted early bird rates, less than 2 weeks left, so we encourage you to sign up. Okay, so let's get back to the webinar. In terms of the format today, our presenter, Brendan, is going to present his talk first. It will last about 20 minutes or so. Then the remaining time will be devoted to audience questions. We encourage everyone in the audience to submit your questions by typing them into the Q&A area of your control panel window. Also, if you're experiencing any trouble during the webinar, you can let us know via the Q&A and we'll help you. If you're having any trouble with sound, if you're using your computer for the audio, please just make sure that the volume is turned up. And if you're still having trouble, you could try telephoning in. And if you're having any trouble using the telephone, you can then switch to using the computer. Usually if you're having trouble switching from one to the other, usually solves the problem. Okay, so let's get going. Now I have the pleasure of introducing our presenter, Brendan Delaney. Brendan is a partner attorney at Frank and Delaney Immigration Law, LLC. He is a native of Northern Ireland, and he received his law degree from the Catholic University of America in Washington, D.C. in 2008. Brendan works extensively with scientists, researchers, physicians, and other professionals, as well as with organizations and employers in both academia and industry with regard to their U.S. immigration and visa issues. And of course, that will be the topic he talks about today. Brendan, welcome. It's really great to have you here. Please go ahead.
All right, thank you so much, and I will go ahead and get started. So first of all, good morning, good afternoon, possibly good evening, depending upon where you are. And we are going to go ahead now and start talking about some of the visa and consulate related issues that will be in play or possibly be in play for you with regards to the upcoming conference, the World Conference on Pain in September in Boston. So just at the outset, I just want to sort of make clear here, we view this as an informational and educational seminar and webinar. So if there may be individual purposes, and this is not sort of legal advice per se, but just to provide you with the necessary information in a general sense. So I want to start by saying that as you sort of navigate this process or these issues, it's paramount to be prepared. Start this process early and familiarize yourself with the necessary information for the application that you are going to pursue here to get this visa if needed. One thing that you can do is obtain a letter of invitation from IASP, which will facilitate you putting yourself forward to the consulate when you go ahead and make the visa application. A couple of sort of points to make at the outset. It sounds simple, but check your passport. Make sure that's done well ahead of time, because it's got to be valid and have at least 6 months left on its expiration date from the date of your return to the United States. And ultimately also know which visa and process applies to you. At the outset, we're going to talk about the two main visa processes that will apply to people, and so know which one applies to you, and then that way the process will be slightly easier to navigate. So the first one is the visa waiver process, which is also sort of interchangeably talked about or known as the ESTA system. The visa waiver process is for citizens of certain countries who don't actually need a visa to come to the United States. So as was noted at the outset, I'm from Northern Ireland, so if I was to come for a conference, I could come on the visa waiver process because they are one of the countries that are exempt. A couple of things to note, however. It seems kind of straightforward, and for the most part it is. It's got to note that travel on the visa waiver process must be for a purpose which is also allowable on a B visa, and attendance at a scientific or research conference is indeed a purpose allowable. So for this, if the visa waiver process is available to you, then it is an applicable method to attend the conference. You got to register in the ESTA system, and you go to the CBP website and complete the application. You can check your status on that same website, and once you're approved, you can then come to the conference on the visa waiver program. However, it's important to note that even though you may be a national of a country, citizen of a country who is eligible to utilize the visa waiver, there are going to be some situations where you as an individual may be ineligible for the program. And if, for example, you are from a visa waiver country, but you have traveled to or been present in the countries as listed on or after March 1st, 2011, you are ineligible to utilize the program. Furthermore, if you are a national of a visa waiver program, but are also a dual national of Iran, Iraq, Sudan, or Syria, you are ineligible to use the visa waiver program. Furthermore, if you have previously violated the terms of the visa waiver, and for example, you may have come on a visa waiver previously, but outstayed it, you may have stayed in the United States for 92 days instead of the allowable 90 days, you must then apply for a B1 visa. So just because you are potentially ineligible for the visa waiver does not mean you are ineligible to come to the United States. There are just certain circumstances that would mean that you then actually have to apply for the B visa. So you want to review these circumstances before you actually determine if you are eligible. If you are not eligible for the visa waiver process, or you are from a country that is not part of it, then the appropriate visa is the B1, B2 non-immigrant visa. And there's a couple of things I just want to note here, and this is going to be the normal or the commonly utilized visa that people are going to apply for. Different consulates have different rules. There are a number of local rules that will apply to certain consulates across the world. So it's going to be important, as I said in the previous slide, to be prepared and understand what process applies to you. Now, a couple of points. Practically or procedurally speaking, you basically complete the DS-160 form online, which is the non-immigrant visa application for the State Department, and then you'll submit that with digital pictures. Ultimately, you then make an appointment for the interview, which is again done online, and pay a non-immigrant visa fee. You will be scheduled for biometrics, your fingerprints, to allow the US consulate to undertake background checks, etc. And then you will ultimately turn up for the visa appointment. A couple of things to understand and be aware of about the B1 visa process. First of all, the B1 visa is the appropriate visa to request. You may see, read, or hear about the B1, B2, the B1, or the B2. These are, in many times, talked about interchangeably. But in effect, the B1 is the business visa, the B2 is the tourist visa, and ultimately, it's the B1 visa, which is the appropriate method for attending a scientific conference. One of the most important questions that you will need to address in terms of the B1 process is, what is 214B? And 214B relates to your home ties. The B1 visa is a non-immigrant temporary visa to visit the United States for a short period of time. And therefore, one of the concerns of the consulate is that people would potentially utilize the B visa to gain entry to the United States and then remain here or attempt to change status here to some other non-immigrant or immigrant status. So therefore, you may, and in all likelihood will, have to convince the consulate or show the consulate officer that you have home ties, that you will indeed return home after the conference. And so therefore, when you go ahead for your interview, you need to have information that will be ready to rebut what we call a 214B finding. And that would include things like wages, a letter of employment, housing, and other living details to confirm your home ties for your own country. So what about the interview itself? When you turn up for a B visa interview, I've got some sort of points to get across to sort of prepare you and get you ready for what you need to think about and contemplate. It's very important, as I said earlier, and we'll probably say this time and again, is be prepared and be organized. Initiate this process sooner rather than later. Ultimately, you need to answer each question truthfully and fully. I would suggest there's no need to necessarily volunteer information outside the parameters of the question, however. But again, provide the officer with succinct and on-point answers to their questions. If you don't understand the question, you can always ask them to repeat or rephrase it. It's important to note the interview is going to be conducted in English. So if you are not comfortable conversing in English, that's something that you will want to take into account. Again, if you are coming to the conference, then please bring documentation to back up any claims you are making. For example, you bring the letter of invitation, bring your conference registration, your hotel reservations, etc. I would suggest not making travel plans, i.e. Buying an air ticket until the visa is issued. Obviously, most air travel is non-refundable, so you would not want to buy that ticket prior to getting the visa issued. Again, I just want to go back, as per the last slide, be ready to show your home ties. Be able to show that your current employment, what your job security is, lease or ownership of property, etc. And I think ultimately you want to be courteous, even if the officer is not. They are supposed to be doing their jobs, but in life we do encounter some people who are less than courteous, but remain calm and courteous yourself during the interview process. One other issue, I just don't have it up here, but I think it's important to note that this is not generally a lengthy interview. So you need to be brief, succinct, and on point. So the information that you will want to bring to show the officer should be able to therefore see the bigger picture very quickly. So be brief and maintain a positive attitude, because the officers will generally be overwhelmed and you need to be able to get your point across quickly, and therefore first impressions matter. So be prepared, be organized for your interview. Assuming that the interview goes well, you will be issued the visa and you're good to go. However, over the last few years, we have encountered more frequently some issues, what we term administrative processing. Administrative processing is a fairly broad catch-all that in effect has entered the vernacular of the sort of immigration and visa family or community as 221G. And 221G, as I said, is a fairly broad overview that gives the consulate administrative reasons to delay an applicant. Generally speaking, this will be because additional research or time is needed to ensure that the individual is admissible for the visa and that they will in fact be issued the visa. Generally speaking, this pertains to a delay in the adjudication process of the visa. However, under certain occasions, it can be treated as a denial and an applicant may need to therefore reapply. This can be a frustrating issue, and right there at the bottom, the broader issue of 221G administrative processing is a big reason to get started early. And a couple of reasons that administrative processing can sort of rear its head is it could be security or criminal issues. It could be a name check. It could be your name could be similar to someone else's who is on a watch list or something similar. And this could all trigger additional processing by US clearance or the consulate. If the US consulate causes the delay, there could be other issues. It could be authenticity of documents. It could be researching legitimacy of your employment, or for example, if you were providing information about a marriage or dependents or previous work. One issue, if you run into delays, is I think where we say here is to need to keep on the consulate to get them to finish the research. Usually my rule of thumb is that if you don't have a decision in 30 days, you should then recontact the consulate to try and get information from them. Each consulate should have an email address where you can contact them. If the email address doesn't get you the answer you need, it's probably best to make another appointment. But again, generally speaking, 30 days after the initial interview would be an appropriate time to contact them. And again, this is the reason, get started early, because there can be delays in visa processing. Where should one apply? Generally speaking, you will want to apply in your home country. If, however, you are residing in a country other than your home country, you may wish to apply there. A couple of quick notes to make about what's called third country nationals is that generally speaking, you have to have what's called a valid reason for applying in the country where the consulate is located. That could be you're working there. You're working in the country where you wish to apply, but not living in your home country. That could be a valid reason for applying as a third country national. You can't simply apply elsewhere just because you don't want to go to your home country consulate, because you've read that your home country consulate is more difficult. As I said, you have to have a valid reason to apply for it as a third country national. And also keep in mind that if you are hoping to apply as a third country national, you should check the requirements of the consulate. Certain consulates will process cases for third country nationals, others may not. So again, you should educate yourself with regards to the particular consulate before you decide that you are in fact going to apply there. How long is this going to take? Well, unfortunately, I don't have an exact answer on that. There are going to be significant differences in terms of different individuals and different applicants. Furthermore, different consulates have different time frames. You can check to see what the time frame is. Now, again, keep in mind that when consulates and the State Department talk about the time frames for visas, these are generally speaking the time frames to get a visa appointment. So, for example, in Abu Dhabi, the wait time for a visitor visa is 8 calendar days. That's generally speaking the wait time to get your appointment and does not include the actual processing of the visa application. So again, the earlier you start, the better position you will be in order to get the visa processed and issued in a timely manner. And understand this, is that as you apply for a US visa, your entire US immigration history is in play. So if, for example, you previously resided in the United States on a student visa, a J visa, an exchange visitor program or something like that, and there were previous issues, but you've been back in your home country for a number of years, the consulate can look at those old visa applications and your old visa history. So it's important that as you sort of navigate this, to understand that your entire history is in play as you go and apply for this visa. Now we're going to sort of transition into some of the more nuanced and potentially problematic issues that people may run into. And again, this is, I'm going to have to generalize here, and it's difficult to get into individual issues or individual circumstances in the context of this webinar, but here's some things to keep in mind. If any of the above apply to you, as I said at the bottom, get individual professional advice. It's very important to know how this applies to you and how this may affect your process. But a couple of issues. If you misrepresent, generally speaking, misrepresentation in a visa interview applies to obtaining an immigration benefit. It's supposed to be material. However, and this is a little difficult to quantify, but there is clearly reports out there that any misrepresentation is being used by consulate officers to potentially deny applications. And so therefore, I think this goes back to one of the earlier slides when we talked about navigating the process and understanding the process. And indeed, for example, even the application process of the form itself, to make sure that any forms and any information that is being provided to the consulate is accurate. We really don't want an individual getting tripped up by a consulate by a mistake that is not a misrepresentation. It's a simple mistake. If that's the case, you can ask the US State Department to potentially intervene to look at this, but again, it's a time issue, and this could take weeks or months for them to in fact influence or have the consulate look at your application again. This can be made more difficult in that the consulate may or may not even tell you what they felt the misrepresentation was. And in a broader sense, that is, I think, one of the difficulties that one can run into with consulates is the lack of actual information that they provide to you. Some of the other issues that you can potentially run into are criminal. There's different US entities, Department of State, United States Citizenship and Immigration, Customs and Border, and they don't all necessarily agree on which crimes potentially render someone inadmissible for a visa. Cautions. This is a big one for people from the United Kingdom. A caution in the United Kingdom is generally a low-level misdemeanor, to use an analogy, that doesn't necessarily result in guilt. However, for purposes of immigration, US immigration, an admission of guilt can therefore be considered to be enough by the consulate. What I would suggest is that if you have ever been arrested, cited, detained, it was important to contact an attorney and get individual professional advice before you process the application. Some of the other relevant issues are as follows. There has been a significant sea change in the State Department over the last few years in terms of their approach to alcohol-related convictions, and in fact, alcohol-related charges. if you have been charged and or convicted for an alcohol-related offence, the State Department is now in effect looking at this as a health-related issue. So for example, even if you currently have a valid B1 visa in your passport, if since the time that visa was issued, you have a alcohol-related conviction, then you will have to, in effect, go and get the visa reissued. Generally speaking, the individual will be required to undergo a medical examination by a panel physician to determine if they have a disorder associated with alcohol use that may pose a threat to property, safety, or welfare of the applicant or others in the United States. There can be inconsistent views of how these panel physicians are viewing these things. So again, if this applies to you, please review this individually before you initiate the application process. What about social media, phones, and computers? The bottom line is that US Customs can look at your social media. They have the authority to do so. We have had information that they are doing this. It is a little difficult to quantify the extent to which this is happening or how common this is. What I would suggest is that you need to be aware of this, and upon your entry to the United States, be aware that they have the opportunity to review confidential information on your devices. And with that in mind, is that when you come to the United States after issuance of the visa, or indeed entry to the United States on the visa waiver program, that a visa or the visa waiver is in effect an invitation to be admitted to the United States. So therefore, upon admission to the United States, be ready to have your information organized and all together as you seek entry. Well, what about the travel ban? I'm sure this is of interest to a number of people. Chad is actually off that list, to my understanding, as of the last few weeks. But in effect, if you're from one of the other countries, you have to understand how this can affect your visa application and your visa process. Possibly some of the countries there will be affected in terms of, for example, Iran. Right now there is no issuance of non-immigrant visas, for example, to come to the United States. So you have to understand if you are affected by the travel ban. Now, obviously, the travel ban is currently caught in court, so it's quite difficult to sort of determine or ascertain how this is going to play out over the coming months. So I think the best thing to do is to keep an eye on this and to sort of understand where it's going. But right now, that's the current state of affairs. And so, again, familiarize yourself with it to understand whether you are affected by the current travel ban. There are waivers. There are potential waivers to the restrictions. However, it is extremely rare. The most recent numbers that I have is via a Reuters report in March, which indicated, which I believe was pursuant to a request from a couple of senators, Van Hollen and Flake, that indicated that approximately 8,400 waivers were requested to that point, and only approximately 100 were granted. So that's an indication of approximately 1%, a little over 1% of the waivers that were being requested were being granted. Now, unfortunately, one would think that due to some of the language used, i.e. that a waiver, some of the language used applicable to waivers, travel for purposes related to an international organization, previous admission to the United States, or significant business or professional obligations, would fall within the parameters of attendance at an international conference. It can be hard to say whether this would be applicable or whether it in fact would be processed. It's clearly very subjective and difficult. But what about the travel ban? If you are a dual national and you can get a visa based upon another nationality besides the ones listed on the previous screen, you can do that. So example, if you are a national of both Iran and Canada, you can still get a non-immigrant visa based upon the Canadian nationality. So if you are a dual national, the travel ban can be avoided. If you're in the United States, I know this doesn't necessarily apply to perhaps the majority of the audience today, but if you're in the United States, You do not necessarily are affected by the travel ban unless you potentially, travel outside. It could be problematic there. If you are outside the United States and you have a valid visa and you do not need to obtain a new visa, you should be exempt. If you're a permanent resident of the United States, you should be exempt. Again, there may be other certain more nuanced exemptions, but again, if you feel the travel ban applies to you, I think you should seek professional advice as to determine or see if there's something that or some other method that you can potentially utilize. I'm going to finish off with looking at as you sort of enter the United States and when you're here and what the sort of final processes of this is. Please be sure to adhere to the requirements of your visa while you are here in the United States. Do not engage in anything that could be considered to be unauthorized employment. I understand that the majority of the individuals in our audience today will be coming legitimately for the conference, but don't engage in anything outside of that that could be considered unauthorized employment. Let's say, for example, someone in a lab or something like that says, could you come and collaborate briefly while you're here? Just because it's unpaid doesn't mean it's not employment. So be very careful about that. A couple of other issues is that if you are attempting to utilize a visitor visa to come to the United States to then change status to something else, that is certainly frowned upon, and therefore we are under a sort of new 90-day rule that violation of status within 90 days of entering on any non-immigrant visa, then that brings into play what I would call a presumption of fraud and at the very least misrepresentation, and could have significant implications for your future visa issues within the United States. So with that, I'm going to finish. I hope that that has been helpful. I hope that this will enable and facilitate many of you to now successfully navigate the US visa process, and that IASP will see many of you in September in Boston. So thanks again for having me, and I'll send it over back to Neil, I believe.
Okay, great. Thanks, Brendan, for that great presentation. Very informative. I just want to remind everyone in the audience that you should keep submitting your questions to us. We have plenty of time. And again, you can just do that by typing the questions into the Q&A portion of your control panel. We've actually received a number of questions already, so maybe we'll just get right to it. So there is a student who is based in Libya at Tripoli University, and noted that the B visa is suspended after presidential proclamation there. And questioner would like to know if there's any way to apply for an F1 as a student or J1 as a researcher to attend and present his research. So is an F1/J1 visa acceptable?
It's conceivable, and this is quite a specific question, and this is one of the quite difficult questions to look at, I think, in this specific situation. I think that there could be a possibility of a short-term J. That, however, would be something I feel I would have to look into outside of simply giving an answer on the fly. We would have to look at the regulations associated with that. I would not see an F1. My understanding from the question is this individual is a Libyan national in Libya at university, so he or she wouldn't be coming to the United States as an F visa, as a student visa. It's possible that a J visa may work, but I think that would be a issue or a circumstance that we would have to look into further.
Okay, great, thanks. Another question is just in terms of delays. If there are delays in this whole visa process, how should people follow up? What sort of steps should they take?
So generally speaking, I think the first course of action would be to send an email to the consulate who was processing the visa. And if they can do that, then hopefully the consulate would recognize their concern and communicate with them. If they don't get communication back, or there's a lack of communication from the consulate, then I think making potentially an in-person appointment to go back to the consulate would be appropriate. After that, it may be possible to go through the State Department in the United States to try and have them contact and communicate with the consulate. But what I would say is, to just go back to what we obviously hit upon on a number of occasions during the webinar, is to really move forward sooner rather than later, because consulate officers and consulates have a significant amount of discretion in processing visas. So ultimately, you know, there's no actual answer, but I think those examples that I just gave would be the way to initiate the requests and the communications with the consulates.
Okay, great, thanks. So there's one question that is specific to person, but may actually be applicable to others. So someone is asking that, or noting that they have quit their present job and are going to be starting a new job in a month, and wonder if it would be better to apply for a visa after starting their new job. So are there any issues, any things to think about in terms of a person's job situation with regard to visas?
Sure, and I think that that is a good question, and I think it does possibly pertain to others in the audience. And in saying that, there's not a one-size-fits-all answer here. I think what we're going to go back to here is that the 214B issue that I noted earlier in the webinar. And so therefore, I think having a job, you are better placed to apply for the visa at that time, because that does provide verifiable information to a consulate officer of a tie, of a home tie. And so therefore, being in between jobs, let's say, a consulate officer could consider or determine that this person could conceivably come to the United States with a view to looking for employment in the US. So I think in that circumstance, being employed, having a letter of employment, and again, obviously with supporting materials such as where you live, housing, family, things like that, would provide a stronger visa application than presenting oneself when they are unemployed.
Great. And actually, the same questioner related to that wants to know whether a person needs to show that they have funds in a bank account to the visa office. Is that a factor at all?
I mean, it can be, but I think that can be a common misconception, because money in the bank doesn't necessarily pertain to someone having home ties, right? I mean, I think that there is, just to reiterate, there is a bit of a common misconception that simply having funds in your bank account that shows that you can come to the United States and financially support yourself during the period of time you'll be here for the conference, let's say. I mean, yeah, they may ask about that, but I think they're generally more concerned about what are the ties to your home country. You know, what's going to lead you to return to your home country after your conference attendance. And again, you know, not to repeat ad nauseum, but it's going to be employment, it's going to be family, it's going to be housing, it's going to be other issues like that, rather than simply having money in the bank. So could be a factor, yes. Is it generally a determining factor? No, I don't believe so.
Okay, and actually related to this, so another attendee was asking whether they needed to provide a bank statement, but also was asking about whether they might need to provide a certification letter from the organization where they work to persuade the consulate.
Yeah, you know, and again, I mean, you know, for better or for worse, I guess I have to generalize a little in this situation. Different consulates, different consulate officers may have slightly different requirements. I think that when you go back and look at those sort of home ties, then there's different factors are going to play into this. And maybe to even bring back the question that was asked a moment ago, you know, who has the stronger home ties? Well, I mean, if someone can show not only that they are currently working in an organization or institution, but they have been working there for a number of years, and you know, that's a more solid argument than even potentially someone who is starting a position. So I think some of these questions clearly are individual in nature, and yes, it's important to get information and documentation like that, and you can supplement and complement it in different ways based upon your own circumstances or situation.
Okay, great. And in terms of documentation, someone wanted to know if there's any documentation with regard to the meeting that they may have received from IASP that would be good to show to the visa office, such as a travel grant certificate from IASP?
Yeah, I mean, again, I think as I noted potentially at the outset, I'm just going to look back through some of my own slides. I think it was in, yeah, it was in the, when I talked about the B visa process. You would want to have information under the interview tips. Actually, the slide it was there. So if going to the conference, for example, bring the letter of invitation, the registration information, the travel grant, etc. But again, I think it's important to keep in mind that while a lot of that information pertains to the legitimacy of the individual's application to come to the conference, the consulate's always going to be, or maybe not always, but generally more concerned about will they return to their home country after it.
Okay, great. Another question has come in about the process for accompanying persons. So if someone wants to travel along with the Congress attendee, any suggestions or any thoughts about that, how to process and go through this process for accompanying persons?
Sure. I mean, one aspect of the DS-160 is that a family application can be processed. So that's a procedural question. And again, I think IASP do have some good information on the website, on their own website, that I had looked at previously to sort of, indicate visa and entry requirements to the United States. So from a practical procedural standpoint, that can sort of push you in that direction there. Again, unfortunately, to just, answer in the same way, a lot of this, I mean, it's a bona fide application. It's a bona fide reason for a spouse or potentially significant other or child to accompany an individual to the conference. There's no problem with that per se. I think, again, if it's a, let's give the example, if it's a husband and wife and they have no children and they're coming to the United States, are they going to be perhaps provided with a higher degree of scrutiny than a husband and wife who have a couple of children and their children are at home during the conference, who are staying with grandmom or something like that? So again, case by case basis, goes back to the home ties. No problem per se with a dependent, or shouldn't be a problem per se with a dependent accompanying the individual to the US for the short period of time. But again, it can potentially, I think, raise other questions with the consulate as to our old friend, the 214B home ties issue.
Okay, great. So we have a couple of questions about other things that people may want to do while they're visiting the U.S., things, tourist attractions and things like that. So people are wondering if you might be able to say a little bit about that, if there are any limitations as far as that go, any issues, anything to keep in mind in terms of other activities people may do while they're in the U.S.
Sure. So, when you come on either the visa waiver or the B visa to attend the conference, you can go and do other things. You can go and visit other parts of the United States. You can, if you have friends or family, you can go and do that. You can engage in, tourist and leisure activities. I don't think there's any, you'll obviously be networking. And so I think all that is fine. And as I mentioned in the webinar, the one issue or the one aspect that you want to be careful about is the idea of unauthorized employment. And I think there's a common misconception as to what constitutes employment. I frequently get asked about, well, I'm going to volunteer. Is that okay? And my answer is, well, yes, if it's a bona fide volunteer position. But if it is, for example, something that, but for it being called a volunteer position, or but for you volunteering your time, someone else could potentially be paid for that, then that could be constituted as unauthorized employment. I think the example I gave in the webinar was, if, for example, you're at the conference and a colleague, a professional colleague says, listen, I'm in the middle of this project or initiative, could you come and look at that with me? that's veering into a grey area that could potentially lead to someone finding that it could be constituted as unauthorized employment. No bright line there, you just have to be careful. The other thing is that while, I don't generally foresee issues with business networking and the like as being problematic, if you were to utilize the B visa to come to the United States to attend this conference and then look at changing status to something else, getting a H-1B visa, changing status to an F-1 or similar, I think that calls into question what your intent was at the time of the visa application, and therefore there is a higher degree of scrutiny, not just right now, but potentially in the future. So those would be the things, I think, a lot of things that you can do. You can come, enjoy the conference, attend the conference, engage with other business and professional colleagues, go and do other things, but be careful with anything that could constitute unauthorized employment or ultimately trying to change status or obtain some other visa.
Okay, great. One questioner is asking about the timing in terms of buying airplane tickets, and how, should the visa be obtained first before making, flight reservations? Do you have any thoughts about that sort of timing?
Generally speaking, I would, my answer is yes. I'm just going to keep this short and sweet. That I think it is better to get the visa than buy the tickets.
Okay, so obtain the visa first. Okay, a question about getting through the airport. If anyone has any medical issues and may have to take medications for a health condition, are there any issues to consider there?
Sure, and I think, again, it's a good question. I think as I mentioned earlier in the webinar, the visa itself, whether it's the visa waiver or the B1, is in effect an invitation to be admitted to the United States. So when you come to the US, you still have to engage with and be admitted by Customs and Border. And so therefore, if you have any personal or health related issues, I think it's important to have the relevant and appropriate information organized with you to be able to provide to an immigration officer. Now, whether that would be a letter from a doctor or physician in the example that this person gave, that would be appropriate. I think other factors could be just slightly outside of this, and could be actually information about the conference itself, to have your information together. But again, for the question posed, that I think if there are any personal or health related issues, I think you should be ready to have verifiable information from a doctor or physician to attest to that. Okay,
great. Another questioner is asking whether they will be asked in an interview, since they're attending a conference, will they be asked why they're applying for a B1/2 and not just a B1?
Well, again, that is possible, and that's why I noted earlier that I think under that circumstance, you could politely indicate that, you understand the B1 is in fact the appropriate visa for a scientific or business conference, and that therefore that is the visa that they are applying. And as I said, these are utilized and used interchangeably, and it's possible that a consulate officer may issue them a B1/B2.
Okay, great. And actually a questioner was wondering if it would be possible to show one of the slides that you had shown. This was the slide before the slide on misrepresentation. If it's possible to pick that one up. Someone's asking if that's possible.
Which one?
So this would be the slide before the misrepresentation.
How long will this take?
Here, let me just take a quick look. Yeah, so the slide before, so that would be how long would this take?
So, I think I just... I think I just went blank there, Neil.
Okay, here, let's see. You know what I can do?
Let me see. Okay.
There we go.
Looks like, just go. Oh no,
And then you can scroll backwards.
Just go back like this.
Yeah.
Oh, okay, perfect. Thank you. This one.
Okay, yeah, great.
Okay. Is there a question about this, or?
There was not a question. They just wanted to see the slide again.
Okay.
Okay. Couple final questions here. This may be a specific question, but perhaps it will apply to others. One questioner is saying that this is someone who is Spanish and had already planned to come to the U.S. during the summer and has an ESTA. Should it be modified because they're coming to the Congress too? And maybe just sort of the broader questions, are there any issues with sort of making multiple trips if someone is going to be here during the summer and then come back? Any issues as far as that goes?
The first part of the question is a little difficult to answer right now. I'm not 100% sure what they are relating to. I'm going to assume that they are potentially indicating that they were going to come and they were going to stay through the conference, but I'm not 100% sure on that. I have perhaps a better answer for the second part of the question about multiple trips to the United States. I think the answer to that is that if you come to the US on multiple occasions, utilizing either the visa waiver process or the B1, there's not necessarily a problem with that, because as long as you are utilizing the visa and or the visa waiver system for the process it is meant for, it's perfectly appropriate. I think, however, that multiple trips to the United States on either the visa waiver or the B1, you're going to, at some point sooner rather than later, potentially run into a higher level of scrutiny and or questioning by Customs and Border, i.e., why are you continuing to come here? What are your reasons for coming here, etc. But I think on the other side of the coin there, for that person's question, if they were to come for, I don't know, 2 weeks in the summer to go to Disney World, and then they came back in September to go to the scientific conference, there's no problem with that. I mean, it's possible that an immigration officer may ask them about multiple trips, but there's no reason why someone can't come to the US for other professional or leisure activities earlier in the summer and then to attend the conference in September. Shouldn't be a problem there.
Okay, great. So I think we've answered the questions. Is there anything else, Brendan, that you might like to emphasize here at the end? It sounds like really getting started now and getting started early is really one of the key things that people can do. Is there anything else you sort of would like to emphasize in the final moment here?
Sure. I mean, I think that that's the main point. I mean, the main point to get started earlier, get organized and be prepared is really important. I guess for just one final point would be that, you know, I understand that there's a lot of rumor and conjecture out there about the visa process for people, and certainly from certain countries, without getting into the countries involved. But I think that if you are in a position to have a legitimate application for a B visa to come to the United States for this conference, I wouldn't be put off applying. You know, if you have the relevant home ties and you have the professional background, don't be put off by making this application and getting your information together and putting the application in front of the State Department and the consulate to request issuance of the visa. Because, you know, my hope would be that these consulate officers will recognize, you know, the importance of this conference. They will recognize the importance of the professional individuals who will come to attend, and that an appropriate application placed in front of them will be adjudicated favorably. So I don't think you should be put off by simply some of the rumor and conjecture that we're hearing in a broader sense.
Okay, and just lastly, in terms of the travel ban, if there are any changes along those lines, I guess people should just stay alert about that. Is there anything that you recommend in terms of what people can follow and resources just to stay up to date with any changes there might be?
Yeah, I mean, that's a difficult one. I think that, yes, I think you have to stay alert. You have to maybe try and look at things that actually transpire. You're going to hear a lot of rumors and a lot of conjecture over the coming months, and I think you have to stay grounded and actually look to official government sources to actually see what is in effect happening.
Okay, great. Well, we've just about come to the end of our time here. Brendan, I wanted to thank you so much for presenting the webinar today. Very informative and very helpful for folks who are planning to attend the Congress. So thank you so much for that. Just a couple of final things for everyone. If you are looking for some more resources in terms of visa and entry resources, there is a travel information section on the World Congress on Pain website, and you can see the URL up on the screen right now. And also, if you need professional advice or have questions, especially if you have specific questions, specific to your individual circumstances, questions about obtaining a travel visa to attend, you can contact us at IASP at members@iasp-pain.org. You can also call on telephone 202-856-7400, and we'll help to connect you with the right people so that you can get advice and suggestions for your specific circumstances. Okay, with that said, I'd like to thank everyone for attending the webinar today. We hope you enjoyed it. And we are looking forward, again, to seeing all of you at the World Congress on Pain in Boston in September. It's going to be a great event, and we're very excited, and we can't wait to see you there. Okay, everyone, thanks so much for attending. Take care. Bye-bye.